Hello, and welcome to Gateway to Privacy, a podcast from global law firm K&L Gates, where we discuss the latest developments and best practices in today's data protection, privacy, and security industry. We hope you enjoy this discussion. Please reach out to suggest topics or guests, or with questions about data privacy law.
Thank you very much for everybody to join us again. This time, we're having our first guest on our podcast, Arya Tripathy, who is a partner at PSA Law, practicing a privacy attorney in India, talking about one of the hottest topics in the data protection world these past few weeks, which is the new Indian data protection law. Joining us as well from the K&L side is Whitney McCollum. Hi, Whitney.
Hi, Claudia.
And that's also the first time we're on the same podcast episode together.
It is.
That's a lot of first time, like building bridges. And also with us is Camille from the Paris office. Hi, Camille.
Hi, Claudia.
So let's jump right into it. Arya, first of all, how are you surviving the wave of inquiries about the new framework?
Thank you, Claudia. But first, I'm super thrilled to be doing this with each one of you. How am I scaling through? Actually, it's a question that merits a lot of answers, but I think I'm telling everyone to take a breather. While there's a lot of hue and cry to rush towards compliance, what is being completely ignored is that there is going to be a transition timeline. The transition timeline is 12 months, which I, in my fair estimation, think is going to be decent, not really lesser time or more time, but decent to be at a place where the house is more or less in order. So first thing that I tell my clients is that you need to pace a little. And then the next thing that I've been telling is if you really want to get started, the first order in business is actually not compliance, but actually doing a data mapping and a purpose mapping. You really can't jump to any sort of compliance without doing these two processes, because the Indian data protection law, which we call as the Digital Personal Data Protection Act, really requires you to focus on data minimization and purpose limitation. So that is what I have been asking everyone to do. And as you would appreciate, it's just not a legal exercise. It requires a team play. It needs a lot of technical skills to be augmented. So my first and most important tip is that clients should start identifying vendors who would be in a position to do the data mapping and the purpose mapping. Might be a little expensive because Indian companies or organizations have never thought about it. But yeah, that's where they have to start.
They haven't thought about it. Do you mean they were not necessarily affected by GDPR before and the whole frenzy that surrounded it 5 years ago?
To be very honest, the answer again is, if you ask if they were 100% inclined in actually complying with GDPR, the answer from my end, at least, based on my experience, would be a no. Large part of the Indian companies who had footprints in EU were classified as processors, and quite naturally, they were handed down a lot of things from controllers' perspective. So literally, like, everything was called out in contracts, in data processing agreements, that you have to do this, you have to do that. Scope of negotiations were very limited. While organizations did take steps, but I don't think Indian headquartered companies really were bothered or affected by data protection law the way they would be by virtue of the DPDP Act. So for many, and for startups, for mid-sized companies, it is going to be quite a fresh start.
Arya, that's been our experience in the US as privacy laws are coming into effect very slowly in the US. The data map conversation is one we frequently have, and we find some companies are willing, but others don't want to do the work. But from the experience of working with companies who do have to have one because of GDPR requirements and have done it globally because it just makes more sense, I say all roads lead to data map when you go through the compliance plan, because it just makes compliance so much easier. I feel like maybe a touch base in a year to find out how implementation has been going with clients once everyone's getting their hands in the data. Could you give an overview of the DPDP Act and just kind of the purpose and the scope, I think we're all very familiar with the GDPR purpose and scope at this point. Many of us think of new privacy laws in the context of, is it like GDPR? Is it not? If it's not, how is it different? You don't need to go into that. We may call out those points, but would love just an overview of what is the purpose, why, and applicability to companies as well.
To simply put, there's a narrow scope, and that makes life easy and hard at the same time. The narrow scope is because it's only focused on digital personal data. It's not focused on any other forms of personal data. And if I have to be completely objective, the biggest fiduciary, that's government, a lot of documentation, a lot of data is still in paper. So narrow scope for digital personal data, but a huge potential for regulation and implementation, because India is fast turning to be a digital power and is very focused on the idea of data sovereignty. Truly speaking, if you classify Digital Personal Data Protection Act as a privacy law, I have a very different stance on it. I think it's just a data protection law because the act nowhere talks about the term privacy as such. The objective is very simple, that an individual has a right to regulate or have control over the processing of digital personal data. And this needs to be balanced with the need for processing of personal data by businesses. So twofold objective. So I think it's important to call out the objective because that's how you're going to interpret rest of the act. India being a common law jurisdiction, we follow statutory language, we follow stare decisis, that is judicial precedents being pronounced by courts. So from that objective, it is going to apply to processing of digital personal data. There are two-pronged application tests. One is that it is going to apply to any data that is being processed in India. And this is very, very tricky because today, a lot of organizations realizing that India is a global player when it comes to data processing, just outsourcing being such a big industry in India, a lot of data that has no nexus with Indian data principles. That is what we understand as data subjects under GDPR. A lot of that data is being processed in India. So that is also covered. So irrespective whether you have an India presence or not, if your digital personal data is getting processed, you need to comply with the Digital Personal Data Protection Act. And the other is what we are commonly called as an extraterritorial jurisdiction, where it applies to a foreign organization that is processing digital personal data for Indian data principles with an objective of offering goods or services. We do not have the similar parallel. Profiling has completely been taken out. So a lot of companies believe that profiling still can be done, but the devil is in the details. Another key feature would be a very keen interest for the government to actually make consent the sole and primary basis of processing. So certain grounds such as legitimate interest or for that matter, repurposing in certain cases, they have been completely ruled out. So really going back to the first point that we started of what people need to do is to actually understand what data they have and why. So what and why. If you have figured this what and why, the rest of the act is going to be pretty much very simple to implement because at the end, we have a very high threshold for consent. Consent needs to be free. It needs to be informed. It needs to be explicit. It needs to be unconditional. So there are too many tick boxes that is very hard to achieve. There has to be affirmative action. There has to be simple language. It has to be published in regional languages. So if you look at just navigating through consent, it is going to be quite a bit of a task. The other piece that is going to be a complete nightmare, if I may use that term for organizations, is honoring data principal rights. Historically, even though the current legal regime did provide for certain data principal rights, I don't think any organization ever cared for those rights. Now you need to really start looking at how seamlessly, how much of automation you want to build in to be able to honor the data principal rights matrix.
Yes, Arya, I'm just going back to what you said before. You talked about statutory languages. So I reckon that there are like 22 languages in India, right?
Yes.
So do you need to, like in the transparency objective, to translate the languages, any of the privacy policy languages you would have into the 22 languages when you are speaking to those data subjects?
Yeah. So I have a very governance-centric approach when I'm working with clients. And I work with a lot of social impact clients who work with really underprivileged communities. So if you expect that they would be in a position to even understand consent as it is drafted with a lot of verbosity in English, I'm sorry, we are even refusing the right for them to be actually informed about what they are consenting to. So a logical corollary of informed is that it should be simplified in a language that they perhaps can understand. So a lot of organizations and in the social impact space have actually gone ahead to use pictorial depictions, no need of language at all, or for that matter, regional languages, which simplifies reading process, the understanding process for the data principle. So I'm not surprised that this is there because as you would understand, India is one country with different languages, and it is quite important for people to be able to understand. Otherwise, I don't think informed consent really matches the threshold. But an interesting corollary is that your data subject rights, commonly called as DSAR mechanisms, they need to be now curated in a very regional fashion, because what is the point of right to access if I don't know what I have to access? So, I mean, the form through which I have to request, the manner in which the response has to come. Now, that doesn't come from the act, but if you stretch that these are consent-related rights, it becomes quite obvious that an organization that wants to comply with the spirit of the law is also having to focus on the rights being enabled in a regional language mechanism. The last thing is about penalties. They are obviously steep. And India has been a country where I think penalties really act as a deterrent in India. How do you implement? How do you enforce? How do you recover penalties? They all are later questions. But I think the idea that there are steep penalties in itself is a big deterrent. And the moment there is one fine or two fine imposed by the regulator that is going to be called as the Data Protection Board of India, I think a lot of organizations are going to be in that full swing where they want to comply with this, because it no longer remains what are the consequences of not complying.
Staying on the track of enforcement, do we already have a clear idea of how it's going to be enforced, like the regional versus the federal level, or are we still waiting for more guidance?
No, that's settled. That point is settled. There is only going to be one regulator at the central level, which is going to be the Data Protection Board of India. In fact, this question was raised by a lot of opposition leaders in the parliamentary process, to which the union minister's response, and I kind of agree with it, is that the moment you do this, that you allow separate regulators for each state, there are going to be massive jurisdiction issues. And they do not want to really deal with that, given the nature of internet per se, where jurisdiction lies. And 1.7 billion people is not going to be funny. So, yes, there will be one regulator.
And you can also try the European model where you got like state, the Data Protection Authority, and then a board trying to regulate. But we're seeing how that worked out so far. I mean, it's getting in line, but still complex.
At least you both have federal data protection law, I would like to point out. So we're still state-based only, minus specific sectors. But I think that approach, seeing how the GDPR has become splintered with regional exceptions and enforcement, and then U.S. state lack of federal law, I think that's a really good approach. So India's looked at others and maybe done a better approach.
It did, because India is a quasi-federal. It was very easy to get influenced because there was quite a bit of lobby for having state-level implementation mechanisms. But I think this is in the right track to have one central regulator.
What was the driving factor behind the state-based regulation versus federal only?
I think it's always a little bit of power play. We are talking about a lot of money that the government is likely going to bring to the exchequer if they actually implement the law, get penalties. So it's going to a fund called the Consolidated Fund of India, which is all the surplus fund goes there. So I think, in fact, there are interesting articles into the political aspects of this particular issue. They really wanted to keep this implementation at a very central level, not delegate out the powers. And the DPBI is contemplated as a digital office. So, the question of whether there is a need for even like having branches or regional offices that operate under the control and supervision of the Data Protection Board of India kind of gets diluted because the design is that it would be a digital office. But that brings me to an interesting point that while everything digital is great, ground reality is that the degree of digital literacy and privacy awareness that is actually needed is nowhere near close to actually making use of a digital office. So I don't know how many complaints from data principals are going to go, whether the digital office really solves any practical purpose. A lot to see when actually the act gets implemented.
Something that is recurring in Europe is that the supervisory authorities are always stating that they're underfunded, understaffed, that there's an explosion of complaints because of the raising awareness of the data subject. Do you think the board will effectively have the means to the political desire?
Okay, very tricky curveball question, because one of the biggest issues around DPBI is that you have no visibility on its composition. Who all exactly would sit in DPBI's office is something that has been left to delegated legislation, that is rulemaking. But what I can tell you that the idea was to have an independent regulator. The law says that there would be an independent regulator, but there are various grounds by virtue of which, even without going to the rules, one could challenge the independence because the officers would be appointed by the central government. So the question of independence becomes really critical. And given that situation, if you ask me if somebody could be politically inclined to support the existing government, I would not be surprised. Because what you need to understand is that so far, state has been outside the purview of data protection norms. It applies to private parties. It is the first time that state and state agencies would be equivalent to data fiduciaries, and they need to themselves comply with this law. So really, I mean, there's a lot of conflict of interest, and I don't think that you can really come to a conclusion that they're independent when there's so much of conflict of interest.
Would you expect any regional agencies or annexes of the supervisory authorities to be created to manage locally more the compliance with DPDP Act?
I wouldn't rule out that possibility, but as I was stating, that they plan to do it as a digital office. The idea for digital office is that you never know who is the person behind that digital office. So, I mean, it's all going to be in the internet. I don't think you will find an office that's earmarked as a state level or state branch office of the DPBI. There's not going to be any such setup. Everything is going to be completely in a digital form, starting from making complaints to issuing notices and perhaps even adjudications. Actually, adjudications can pretty much happen virtually these days. So I don't anticipate they actually coming up with state level branch offices. But I mean, if the intent is that people really make use of this law, if it is people-centric, then I think one important task is advocacy. The more the DPPA focuses on actually individuals being aware about the concept of informational privacy, about what their rights are, how they can best make use of it, that's perhaps going to be one of the reasons why the suggestion that you're making that state level agencies for compliances or for just handholding might come true. But yeah, advocacy doesn't come as a core focus area. And if I were to pick from GDPR, I think it took quite a bit of advocacy to actually get to where we are when it comes to GDPR, with supervisory authorities actually actively engaging in discussions with corporates and individuals.
Arya, what's the ability of individuals to seek recourse against a company for violation?
Not much. The earlier versions of the law did contemplate a very far-fetched idea of some amount of compensation to an individual who may have suffered a breach or whose rights may not have been honored and respected. But all of that has been omitted from what we finally see as the law. So the only remedy is possibly that you can raise a complaint with the DPBI after you have exhausted all remedies in a private horizontal capacity. So if I asked for access and you didn't give me access, and I have raised it with my consent manager, and they are unable to make the fiduciary come up with that necessary response, then perhaps you will have to just file a complaint. But as an outcome, I don't think there is going to be any compensation. Whether there is tangible harm or mental harm or intangible harm of any other kind, I don't think compensation is coming through.
That will be an interesting piece too on the advocacy and the why should I exercise my rights, especially if companies are not complying and there's no enforcement. So, but I think Claudia and Camille, interesting from the EU perspective on recourse for enforcement of rights. I know complaints are really common in the EU for lack of enforcement. In the US, there's a new concept of data subject access rights, and it's similar that you can make a complaint. There's no individual recourse. So it's really up to the authorities for enforcement.
And also it takes time. When I look at what's happening under GDPR, like there was the introduction of group action, and this takes time to get underway. So once again, it all starts with awareness, evangelization, and then to grant the people the means to the political willingness to implement a virtuous system. Arya, early on, you talked about data sovereignty, and I know sometimes we're creating a position between data protection in the EU and data protectionism, notably with regard to China's PIPL. Where do you think, or where would you say India is falling on that spectrum? Because you clearly stated it's not a fundamental right. It's a data protection. There is no notion of privacy, but it's not necessarily considering data as a pure commodity either. So are you in the middle? Are you leaning one way? Are you creating a third axis?
I don't say there is no data protection. Informational privacy, one of the important aspects is data protection. It just caters to that single aspect of informational privacy. Tomorrow, I can anticipate of a situation that, let's take the example of state as a fiduciary, because really the concept of fundamental rights is still to see horizontal enforcement in India. It's more in a vertical capacity, the state versus a bunch of people or a set of individuals. Now, if the state were to not comply with DPDP Act, what is exactly the consequence out of that? Of course, one person could be going to the DPBI to raise a complaint and get it adjudicated in accordance with DPBI. The other recourse that can be availed by an individual is actually go to the constitutional courts, which is the High Court and the Supreme Court, because the DPDP Act only prohibits civil courts, which are not constitutional courts. But one could actually go to the High Court and the Supreme Court, which is the apex body, claiming a writ, because there is an important aspect of the fundamental right of privacy that has been breached by the state actors. So I would not say that there are no components of privacy, because quite naturally the idea of personal data protection flows from informational privacy. But today, if you were to look at it as a privacy law, you would not find concepts such as privacy by design, privacy by default, or for that matter, doing a privacy impact assessment. I think the objective, as I stated, for the law is twofold, that let's make individuals be aware that you have control over your data. There are certain things that people can do with your data. There are certain things that they cannot do. And at the same time, require businesses to really comply with the law to state that this is how you can process if you're processing in India. That is where the data sovereignty concept comes. It's not stopping data to move out of the country. There is no localization concept anymore, barring few countries that might make to the blacklist, which I think is quite predictable where it's headed to. But the idea is to have twofold control. One, the individual should have control over their own data. And the second is that the state should have control over data.
That's really helpful. And going back to your concept of the what and the why with respect to companies and their data mapping, it seems like this why is a hook for individuals to have understanding and control. And you mentioned a balance of interest. Can you talk more about the whys that the companies need to establish so they're not in the consent mechanism, and that balance of the interests?
Whitney, actually, anything can fit into the why, as long as you are transparent about it. If you tell me that I'm going for a telemedicine consultation and my health data is needed for providing the medical consultation, the why is quite obvious. In fact, there are laws other than the DPDP Act, which says that if a patient walks in and avails of the telemedicine consultation facility, there's sort of an implied consent. So the why one is obviously where it is needed for performance of the contract or for availing of services or availing of goods. you walk into a pharmacy, you don't expect to sign a consent form. Your number is being taken and you're given a receipt, an invoice. That is an implied concept. But then if today I say that I'm a telemedicine platform provider and I'm going to take your data and give it to a pharmacy company, and if you have not read it, if you have given your consent to as clearly as the way I stated it, that your data is going to be shared with a pharmaceutical company for research and potentially discovering new drugs. If you have consented to it, then that why is solved. Whether it is actually connected with the actual specified purpose or not doesn't matter. So what the law is headed to is how transparently you are telling people that your data is going to be used for behavioral advertisement, your data is going to be used for marketing, your data is going to be sold out in the market to other players who can then reach out to you. This is exactly at the core. I think somehow I like the idea of consent because I understand how it works. But from a very practical perspective, it's hard to see how people are going to whether people are actually going to read through it or not. And we are headed to a graded sort of a consent, a layered consent format that you can't have pre-tick boxes. You need to say that ABCD data is needed for a specified purpose, and be precise, be specific about it. There's no room for any sort of ambiguity. So while it might look like, oh my God, I don't have the subtle way of processing data, that's exactly what the law is striking at you. There are no more subtle grounds of processing. You disclose, you take consent, and you process data. Barring a few situations, which are the exceptional grounds of processing, such as employment-related data. You don't need any consent. Medical emergency, sovereignty and integrity of the state, or for the state to actually provide you certain benefits. These are certain very limited carve-outs that has been done. But as I said, they're exceptions. They're not the norm.
I'm very intrigued on how you mentioned having pictorial or depiction of to inform the data subject. This was something that was highly encouraged under GDPR, and we're still nowhere near having a consensus on this. And to some extent, I feel like our client, the data controllers or data fiduciaries, are also those pushing to get the legalese and not necessarily going for simplicity, because there's something reassuring to having these legalese. So if India could be paving the way for standard on pictorial depiction of information on data protection, I would be all for it.
Yes, and I think that can only happen when people actually realize that's possible when you follow data minimization and purpose limitation. If you want the sun and the moon and the entire galaxy in your consent form, really, I mean, there's no way that you can make it concise, simple, to the point, specific, transparent, so on and so forth. So I think, as I go back to the point, people now need to really start thinking, do they really need the data? If they really need the data, is there a purpose which is mapped and identified to it? Are there lesser invasive means of achieving the same purpose? And really scale back on how much data is being processed.
We could go on for hours and hours. We've already penciled in a year to have you back at the latest on the podcast to see where that implementation has been going. But thank you so much for the highlight of that emerging framework.
Thank you so much. I loved it. Thank you.
Thank you for listening to this episode of Gateway to Privacy. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks. That's HUB Talks in your favorite podcast app. Tune in next time for more data privacy insights.